certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction.
Next case, State of Kansas versus Sydney Taylor Leslie. Ms. Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non.
Right from the jump, Leslie makes it clear this isn't going to be a typical court hearing. Instead of a yes or no, we're diving straight into sovereign citizen territory. Buckle up, because this ride is about to get bumpy.
Same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location, count 3, driver's license in possession, an unclassified non-person misdemeanor. Then count 4, same date and location, failure to register vehicle, and unclassified non-person misdemeanor. Leslie, do you understand the charges pending against you?
I comprehend the alleged charges.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel. If you cannot afford an attorney,
Excuse me, I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights.
This is a classic tactic. Refuse jurisdiction and demand proof of an injured party. But here's the thing. Traffic laws don't require a victim. The state itself is the injured party. Judges know this, but sovereign citizen defendants never accept it.
To counsel, if you cannot afford an attorney, one would be appointed to represent you. And Ms. Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-3 that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden-shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 4, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging and every element of the alleged offense and my commission thereof it has been properly established. Threshold matter of jurisdiction must be adjudicated prior to any other as articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court jurisdiction.
Did you catch that? By calling herself a living woman and not a corporate entity, she's drawing from a fringe legal theory that courts universally reject. It sounds dramatic, but legally, it holds no water.
Jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds and disqualification.
Court overrules the motion.
And here's the irony. The judge labels the behavior accurately, and she calls it prejudice. Imagine walking into a basketball game, dribbling a football, then yelling bias when the ref points it out.
Case.
On
overrules dismissal of the
prejudice.
Case. And the court will find that the court does find it has jurisdiction to proceed, and subsequently the court sets.
I object. You called me a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias.
No prejudice or bias is asserted as to yourself. However, the court, as opposed to trying to write down docket notes to that effect, what you are advising the court that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond $3,000 cash.
This is what we call paper terrorism. Overload the system with endless citations and pseudo-legal jargon, hoping the court gets lost. But judges are trained for this. They'll let her talk, then calmly move on.
Jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas rule of civil, especially not generally, and I have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212. No verified complainant from any injured party has been filed as required by KSA section 22-2301 in Butler County Local Rule. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my hands and was exercising my unalienable right to travel, placing it outside the territorial.
Quick engagement check. What do you think? Should judges call this behavior out directly, or does naming it give sovereign citizen arguments more fuel? Drop your thoughts in the comments.
Rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, it was here due to lack of probable cause. There can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas.
Notice the contrast. Leslie brings fireworks, but the judge ends it with a quiet gavel. That calm demeanor, it's deliberate. Judges know if they match the energy, it spirals out of control. The courtroom wins by staying boring.
And this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predisposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice.